This lecture focuses on product liability, which is liability for harm caused by a consumer product. Within product liability, these are the people or organizations who could be held liable if a product malfunctions and causes injury. The injured person can sue the manufacturer, they could sue the product distributor, or they could sue the company who sold them the product. Product liability may be based on several legal theories in tort or contract law. Under tort law, there's the theory of negligence. Strict liability refers to liability regardless of fault, so whether it be the manufacturer or the person who sold the product or the person who distributed the product, they could be held liable for selling a defective product or not warning people about the product in general. And then finally, under contract law, there's breach of warranty, and I'll go over these three concepts in more detail on the next series of slides. As discussed in the earlier part of the chapter, negligence falls under tort law. Product liability could be a form of negligence. So what would need to happen here for a plaintiff to win a product liability case is that they would need to show that a standard of care existed for the defendant, that the defendant had a duty and responsibility, which is established by industry standards, laws, legal precedents, and regulatory agencies, that the defendant then breached that duty or failed to uphold the duty, and as a result, it caused an injury or caused the plaintiff harm, and that an actual injury occurred, and the plaintiff is seeking compensation for that injury. Another legal theory of product liability is strict liability. Again, this is liability regardless of fault. The plaintiffs using strict liability need to only show that the product was defective when it left the defendant's hand and that the defect caused the plaintiff's injury. In terms of used products, the third restatement of torts states that basically strict liability won't work for used products because used products have been used by other people, and people should expect some sort of defect with a used product. Breach of warranty in terms of product liability falls under contract law. This is basically a remedy for a broken or defective product. Okay? And the contract is created through purchase agreements, and an express warranty is when the seller states facts or makes up promises about the product, and then the product fails to live up to how it was described, or it's just defective in general. And this warranty arises through advertising, sales literature, statements in which the seller asserts a fact or makes a promise that relates to the quality of goods, and that prompts the buyer to purchase the product. Breach of warranty also falls under contract law. The Uniform Commercial Code is a set of laws that govern the sale of consumer goods. And there are two aspects of this: the implied warranty of fitness. This is when the retailer, distributor, or manufacturer knows of a certain purpose for which the product is required and that the buyer is relying on that skill, right? So it's basically saying that the person who's selling the product should only sell people things that are going to work in certain circumstances. Like they shouldn't be selling a college softball team a bunch of bats that aren't going to pass the NCAA test. And then implied warranty of merchantability basically states that the goods will do, or products will do what they're supposed to do, and that consumers can expect that the products are good enough to be sold. This slide discusses the type of defects that result in legal liability. The first is a manufacturing defect. This exists when a product is manufactured incorrectly, and it only affects some products that were produced, not the entire product line. In comparison, a design defect exists when a product is unreasonably designed. So this means that, for example, a company decided to create some shatterproof sunglasses, but every single pair shatters. That means there's probably a design defect and they need to fix all of the products and not just one or two. And then finally, under types of defects, there's a duty to warn consumers of the dangers that exist with the use and and the misuse of products. And these warnings have to be easy to understand and comprehend for people. Product liability applies to manufacturers, distributors, and salespeople. The theory of product liability may fall under negligence and tort law in that there is a standard of care set by various entities, and those organizations need to follow that standard of care, or under contract law, like the Uniform Commercial Code or express warranties that set up how the product is able to be sold, and that it's ready to be sold, and that it's going to live up to a certain standard. And then ultimately, the manufacturers, salespeople, and distributors have a duty to warn or inform consumers about how to use and not use the products that they are selling.